Hi, everybody. My name is attorney Manny Serra of the Rossen Law Firm. The initial client interview. This is something that if you're a public defender, it's likely going to be your first meeting with the client or maybe a call with the client. And if you're in private practice, this can be a consultation or strategy session or phone call that you're fielding from the client or a loved one that you want to touch base on some certain things that are really going to set the trajectory for your case and your defense. So the client interview, we're going to be going through 4 different sections of this one. All right, we're going to have information gathering. This is the key to a great defense. We're going to be providing education. So we want to be experts to our clients and let them know that the law, what the law is in their specific situation, what the court is like, what the judge is like, what their prosecutor is like. Is there a diversion program? We want to come through as an authority. 3 is going to be setting expectations. So no guarantees, but you really don't want a client thinking this is going to be, something from A Few Good Men or a movie that they may see, thinking that we're going to go in there and just, set the courthouse ablaze with great cross-examination and a closing argument on the very first day. And then at the last section of this session, we're going to talk about the 10-day DMV rule. It's a bit complicated. It's going to be a lot to go through, but I will cover the basics, as this is something during your initial client interview, consultation, strategy session, phone call, you're going to want to touch base with your client on because it's very important. So information gathering, okay? So this is stuff that needs to happen prior to you even meeting with the client. What you're really going to want to do is get in the practice of getting information prior to the phone call, prior to the consult, prior to the strategy session, because what that means is you're going to be better prepared. And when you gather information from your client, they're going to tell you what's really on their mind and pressing. Like when you go to a doctor's office and you have all of these thoughts and concerns and you're speaking to your doctor, and if they're going to sit there and look at your chart that you filled out while you're talking to them, do you really think that you're getting the doctor's full attention? No, it's rather bothersome. So you want to really give the client the assurance that, hey, I'm here for you, I'm hearing you out. And if you have some of these concerns outlined before they come in, you can go there and have that empathy with the client and really let them know you understand. And so here's an example, right? A client calls your office and sets a consultation for 3 p.m. the next day. In some form or fashion, I would have a process or procedure or practice that gathers some of the following information, right? The contact information, an emergency contact, a brief description of the facts, the previous criminal history. Always try to double check that looking at the clerk or anything that you may have that can run someone's background. Their biggest concerns surrounding the incident. Immigration status is huge. Okay, the immigration law is always changing. We like to tell clients we're not immigration lawyers. We certainly don't want to know what their status is. And ask if they're currently on probation or pretrial release, because that's, especially if they're on pretrial release, they may need permission to come meet with you in the office. So that's get ahead of, and maybe have an assistant paralegal or yourself reach out. So information gathering. Before it gets started, I want everyone at their firm or their office to get in the practice of running a conflict check. So if you get someone who calls into your office and your paralegal or your intake specialist tells you, hey, this person called, they're coming on in, there should be a practice and procedure to run that person through your case management software or something that you have to see whether you have a conflict with that individual. Because the last thing you want to be doing is going in the middle of your strategy session or consult, having to cut it off, and then now even being conflicted off multiple cases. And so you want to let them know, though, once you've done that, do that clear conflict check, that because they're in the process of seeking legal advice, there is an attorney-client privilege that attaches. So then they can be comfortable. Because another, using a doctor analogy, is if you go to your doctor and you don't tell your doctor that you're having this pain in the back of your neck, you say, yeah, I feel fine, I feel great. You go and you play some basketball and you get into a rough foul going up for a dunk or a layup. What's going to happen subsequent to that is that can exacerbate the neck pain. And instead of something that could have maybe been treated with physical therapy, now you're in the process of looking at surgery. So if your client isn't honest with you up front, it may really deter his or her defense going forward. And so information gathering is the start of your defense. It starts here. So I like to tell clients that if you've ever played golf, right? I'm a very poor golfer. But if you are off by 2 or 3 degrees on your swing, you could be hitting the ball way left, hitting it dead straight, or slicing it all the way to the right. And when that happens, it's usually because of the start of the contact. you know, you can blame the wind if you'd like, but or the club, that's my favorite. But when you're actually going through and approaching the ball and how to swing it and where you're aiming, the start of that is you know, something that is paramount to establishing the proper trajectory of the case. Think of it also as a rocket, right? If a rocket launches by 3 degrees to the left or 3 degrees to the right, then what happens is there's going to be a rocket landing on Mars that should maybe have gone to Jupiter. And so we want to make sure that when we start off, we're starting off on the right degree. Information gathering, the defense starts here, right? So set your trajectory, okay? These are things you're going to want to look out for when you're talking to your client. So a lot of the times you're talking with your client, some lawyers sit back and work on other cases or just kind of let them vent. But really, if you're putting your ears out and catching things, you're going to be able to use that much later in your case in deposition and cross-examination at a DMV hearing that are going to bring up defenses that you would not have had if you didn't listen to your client, such as injuries, physical conditions, speech impediments, language barriers, learning disabilities, right? Where were they coming from? Where were they going to? Defense witnesses or exhibits. Much more that you won't get from the state's discovery. So if a client tells you, hey, yeah, I had surgery on my ACL about 3 years ago, it's never been the same, and in the police report you read it and you're going over it with your client, and it says, hey, he asked you, do you have any injuries or illnesses that may affect your ability to perform these exercises? You told him no. Your client can say, yeah, I just totally forgot, or I blanked, or I was under pressure. And if you have then medical documentation to establish that he was in fact injured, that could be a defense exhibit right there, right? That's a physical condition that may change the course and trajectory of your defense, meaning that he wasn't able to walk in a straight line or stand on one leg because of this previous injury. Same thing with speech impediments, right? Language barriers. Find out if this person was born in this country. You know, it's not offensive to ask. You really need to figure out if this person is being judged on a fair basis. In order to do so, you're going to get to know your client best, right? And we're going to go over later in this presentation about what test your normal faculties, the field sobriety exercises, things of that nature. And they're not always fair, right? They're trying to be fair and reasonable and for an objective basis and for, you know, but everyone's so very different. And where they're coming from and where they're going to. I want to know that because where they're coming from, they may have been with friends who know this person, who know your client better than the officer, who can testify or be listed as a defense witness, who can tell the jury or the court or whoever it need be that I know Bobby. Bobby was perfectly fine leaving here. He only had 2 beers or whatever it may be. And that's strong, right? Because that person's going to know Bobby a lot better than Officer Smith, okay, who just meets him on the side of the road. So these are all things you're going to be wanting to jot down and write down because it's really, really going to give you options for a defense. Anyone who just looks at a DUI and says, this is a cookie cutter DUI, whatever, I'll just go through some stop motions and then, you know, go into my usual spiel as to how the DUI arrest was a whole setup. He was going from A to B as fast as A to Z as fast as possible. That's not really doing a full-on defense. And this is how you start that full-on defense. Okay, get to know your client. What's their profession, right? We let them know we're not employment lawyers or profession lawyers because we don't know how they're going to be regulated, what they need to report, what they don't need to report. We don't have their employment contracts. But certainly, it's going to really change how your client looks at a DUI. For instance, there's a lot of self-employed handymen, right, or self-employed bar owners who don't really mind this DUI on their record. But if you have people that are working in Uber, right, if Uber is very popular, they can have their accounts suspended, right? They can lose their license. If you have a CDL license, right, that's the next thing I wrote on there, right? Do they drive for a living? Do they have a CDL? That changes everything. We could do a whole presentation on CDL, but definitely Google and look that up so you can figure out if someone does have a CDL, how to handle that. You can always, at the end of this presentation, there'll be a QR code for you to scan to give me some questions if you have them. Go ahead and feel free to ask me. I'll be happy to answer them. I just can't do everything right now. Ask them, where do they see themselves in 5, 10, 20 years? Because at DUI, if someone's trying to be a doctor or a lawyer, can really, really hinder their ability to get admitted to the bar or get their doctor license. These are things that we really want to speak with the client about because then you're really going to know, hey, is this client even looking to plea? Can I even accept a plea on his or her behalf? Not on their behalf, but you know what I mean, work that out. and ask them if they have any priors. So what's really important here, since we're talking about first DUI, you guys handling a first DUI, you really want to look to see if they have a prior DUI, because if it's a second DUI within 5 years of the previous conviction, remember this is a second DUI arrest, not second DUI, or excuse me, second DUI arrest, yes, within 5 years of the previous conviction, there's a 10-day minimum jail sentence. So you're really going to want to look at that, because you're going to handle that case not differently, but you're definitely, it's going to be, the stakes are going to be bigger and higher. And it's highly unlikely that your client's going to be A-OK and peachy with that 10-day jail sentence, because they may be shocked to hear that. And how open do they seem to be about a diversion program, a reckless driving, or a careless driving plea? Because you want to, at the end of the day, what I want to do and what I want to give my client is give them an option, right? I'm not saying they have to take this or they should take that. I can give my counsel, but I want them to have options. Imagine if you're sitting in your client's seat, you want the lawyer to tell you, hey, at the end of the day, I'm gonna say, look, we were able to work out X, Y, and Z, which won't result in a DUI conviction, meaning a reckless driving, a diversion program, or even a careless driving, but it may still result in some conditions of a DUI, like a license suspension or probation. You're gonna hear maybe the term of a wet reckless, meaning it's a reckless driving breakdown, but you're really gonna have all the terms and conditions as if it was a DUI, which helps you maybe potentially seal the case off your record and certainly helps with your insurance purposes. But your client may tell you, I'm not interested in any of that. I want to beat this whole thing. And we all have those clients where they say, I'm not taking anything. We're going to court. So you know that you need to dig in for that case. And so that's something you definitely want to talk about. And as we talked about, asking them if they're a citizen, we let them know we're not immigration lawyers and they should consult one. If you don't have an immigration lawyer, a set of 3 or 4 or 5 that you work with, you should establish a reputation with them so that you can refer some clients, because your clients are going to want the best advice they can. And it's great to get one of those plea memos where an immigration lawyer may write for you that you can present to the state attorney to say, look, we can't take this. We are legitimately going to have to go to trial. But if you amend it to this charge, we could probably work that out. That really puts the oil on a squeaky wheel. All right. Number 2, providing education, right? You want this potential new client, PNC, to walk out of your consult with a feeling that you have you are the authority on DUI law. You want to talk about case issues, and you have an intimate knowledge of the court system. This starts before you even step into the Zoom or the meeting with a potential new client. How does that start? You're going to want to go to the clerk of court. You're going to want to pull as much as you can off the clerk of court's website. See who their judge is. See who their state attorney is. Try to pull the police report. Try to pull the DUI citation. What you're going to want to look at, too, when you're looking through those things is maybe already have some things highlighted or circled. So when you sit down with them or talk to them, it's not like you're doing this on the fly. You can show them, look, I got this right here. I got a stop motion, something right here. This doesn't sit well with me. Or this looks like a very formed DUI probable cause affidavit. And those are things that are going to allow you to let the client know that I'm here for you. I'm prepared. I'm ready to fight for you. Okay? So number 3 is setting expectations. And this one is very, very important. Okay? We all have those clients that come in, and as I started in the beginning, that think that when they go into court, there's going to be a jury already waiting, a packed courtroom, a judge who's ready to hear both sides of the case. You're going to make your argument. You're going to be dressed in your best suit. You're going to put on this fantastic presentation before the judge. And at the end of the day, they're going to walk out of there, toast champagne, because we beat the case. Little they know they're only set for an arraignment. And so I want to always tell our clients, hey, listen, the cases of DUI may take 6 to 8 months. It could take 3 months. It could take 12 months. Also, to go back a slide to talk about DUI diversion programs, our firm, the Rossen Law Firm, practices primarily in South Florida. So in the Tri-County area, there is a diversion program for DUIs, if you qualify, in Miami-Dade and in Palm Beach County. But there is not one as of right now, as of November 30th, 2021, in Broward County. So when you're talking to the client in your consult, you don't want them to WebMD themselves and use their Google lawyer acumen, right? And say, oh, but I know that there's a diversion program. How come you keep telling me there's not a diversion program? Well, sir, ma'am, in Broward, there isn't. So there's a different trajectory you may have to take on your case than it would be if it were in Miami-Dade or in Palm Beach County. So that's part of setting the expectations, right? Depositions. In Broward County, more likely than not, you get to take depositions on misdemeanor DUI cases. Now, other people around the country, or maybe even the state here, are scratching their head going, oh, really? But it's kind of normal practice for us. We take quite a few depositions, and it helps us fight our case. However, in Miami-Dade and Palm Beach and in other parts of the state, you have to file a motion showing good cause. And a lot of time, that good cause, even though you really believe it's good cause, the judge is going to deny it and say, I don't find there's good cause to take those depositions. And then you got to kind of get creative with the way that you file a motion to suppress, motion to dismiss, or really get a private investigator may be involved. Those are all things, right, that you want to tell the client ahead of time so they're not going flying, they think you're flying by the seams of your pants, right? This is really important to set those expectations as to how this defense is going to look. You're going to want to go through the minimum and maximum penalties of a DUI. It's a statutorily based crime. So if you look at the statute, you can see exactly what the minimum and mandatories are. For that first-time DUI offender, it could be between 6 months and 12 months probation, right? 6 months driver's license suspension, 12 months driver's license suspension. That's typically what we see coming through, right? $500 fine, $1,000 fine, 50 hours of community service, a DUI school, follow-up treatment, 10-day vehicle immobilization. There could be an intoxilizer put on the car if it's an enhanced DUI, right? An enhanced DUI happens really in two ways. One, if you blow above a 0.15 on the breathalyzer, or two, if there's a minor in your vehicle, someone under the age of 18. You're going to want to explain all these things to your client, and you're likely going to teach them so much more than they can find online, or maybe your competition who's not watching this is sitting there going, yeah, I read the police report, we may have a motion, here's how much it costs, and we need all of it paid up front, half now, half later. Let me tell you how great I am, and then here, hire me. That's not the way that this should go. You should be all ears listening to your client so that you can best formulate the defense and then provide them the best education. So when they leave that office, right, whether they sign up with you or if they don't, and they compare that to someone else, or if you're their public defender and you're telling them all of these things and they go and try to talk to a lawyer, right? Because they go, oh, I don't know if I trust the PD. I used to be a public defender. So I don't know if I trust the PD. I'm going to get myself a real lawyer, right? We've all heard that if you're a PD. And then they go and they talk to these real lawyers, and they come back and go, wow, my public defender knew 10 times more than that guy. And maybe you don't, but you're going to come across that you do because you're eager to listen and share information. Okay, it's your client's case. It's not yours. Remember, the state attorney has files. Civil lawyers, they have files. We have clients. We have families, and we have humans in criminal defense. We want to make sure we treat all of our files as humans, and we let the state attorney know that this is not just a file, this is a human, this is a family, this is a career, this is a future, okay? And all of this is what you want to tell your client when you're meeting with them so that they know that you have their back. And why is that important? Because as we go through the case, or it could take 6, 8 months, 12 months for these misdemeanors, sometimes they take more. With COVID happening, it clogged up some of the court system. You need to set the expectations. Because you don't want the call, hey, you told me this was going to be done super easy and it's been 8 months. Why hasn't this been finished? Or what's going on with my case? Right? You're going to want to tell them when you're going to get discovery. You're going to want to tell them when we're going to communicate with the state attorney. You're going to want to tell them that the arraignment date is a very easy kind of form. You can waive the arraignment date if you want. You can do a waiver of appearance so that they don't have to appear in court. You're going to want to go through all the tools you have as a lawyer to make your client's life easier. And why is that important? Because you don't want to end up like one of my favorite indie movies here, 500 Days of Summer. It's a great scene where it talks about setting expectations versus reality. If you've ever seen the movie, it's a really fun movie. But this guy has this girl. He loses this girl. Her name is Summer. He thinks he's going to win her back at this party. He thinks it's going to go fantastically. And his expectations did not meet reality. And it's a scene that always sticks with me. So forgive me for my poor choice of film. If you've ever been in that kind of a situation and you're going to have these great expectations, these romantic ideas, and then you get that friendly hand pat hug, side hug instead of a lean in kiss, you go and you think you're going to have this romantic dinner, and next thing you know, you're sitting far apart and the two parties are not meeting and the expectations do not meet reality. It's not a great feeling. So you want to make sure, right, as we talked about before, that you give them a fair and accurate depiction as to what's going on. So letting your clients know that this is not a movie. the suits drama and the rules of evidence don't fly, and the rules of evidence don't fly in the real courtroom. So Suits, if you ever seen the movie, it was popular back when I was in law school. Not movie, I'm sorry, show. It's something really, really, and I misspelled peak there. I see Mehdi pointed that out. I apologize. My journalism background at the University of Florida would be very, very mad at me. But what you want to do is let them know, right? Let your clients know that this is going to take time. This is a marathon. This is not a sprint. Okay, you're going to want to avoid and try to don't feel the need to answer that. What are the percentages of beating my case? Okay, there's times where I've caught myself saying a percentage here or there and then immediately taking it back. It's better to just say, this is the tip of the iceberg. Okay, this is the very beginning. We're going to file our demand for discovery. Within 15 days of that demand, the state attorney is going to give us all the evidence in their possession that's going to lead towards proving your innocence or your guilt. If we don't get it, we're going to file a motion to compel. We're going to push forward. We're going to get that evidence. We're going to review it together. We're going to set depositions if we can. We're going to file motions and let them know that this is going to be something that's very tactfully done. And you should set that trajectory with them and give them what you're going to do on the case given some of the circumstances. If you don't have that police report, you just let them know that you can base the best, because sometimes when they come in to meet with you, the police report hasn't been uploaded online yet. And so when you're talking with the clients, you just let them know, we don't have the benefit of reading that report yet, but certainly let me walk you through, given the facts and circumstances that you told me about the incident, how that can play out in my experience in court. And once I get that report, I'll have my staff check daily and I'll send it over to you and we can even talk it over once we get it. Because that's really important, because clients come to you, think you have everything. Think you have the officer's internal affairs file, right? They're going to think you have all the times he's been beat or he's won a case. Your prosecutor, where they went to law school, how many cases they won. You're going to get a lot of that. How many times have you beaten this person? How many times has this person beaten you? Do you know the judge, right? Those are all things you're going to have to address. It's just common. They get asked all the time, whether you're dealing with a public defender client, a private client, a family member. That's all things that we want to discuss. We also want to talk about when we're going to talk again, right? Once the strategy session, the consult's over, they sign up, or you talk to them at the public defender, you meet them, it's great, you have a little conversation. Let them know, set expectations. Hey, we'll reach out to you at the first calendar call. We'll reach out to you when we get that discovery. Let them know when we're talking. You don't want to just have them leave and go scratching their head. I guess they're going to call me, right? Or today is a day, we're after Thanksgiving. A lot of times clients call because they go to Thanksgiving and their aunt or uncle, their friends ask, hey, what's going on with your case? I don't know, I should really call my lawyer. And the phones light up like a Christmas tree. Christmas is right around the corner. And we get the clients coming in, what's going on with my case? That's something you want to avoid, right? Sometimes you can, it's unavoidable, it's human nature, but you really want to touch base with them. You want to touch your clients as many times as possible in the most professional way possible. And then let's go to the next slide. Here's the 10-day DMV rule for a first DUI arrest, right? For a second DUI arrest, this is going to be different, but we're doing the basics here, so let's do a first DUI arrest. So during the client interview, you should be able to answer the following. Do we do the formal review or do we waive it for a quicker path to a hardship license, right? And so a hardship license is going to allow a client to go to and from work, groceries, religious purposes, childcare. Those are things that the hardship license should be able to cover underneath the statute. And you need to know if the client can be without that hardship for a certain amount of time. And I'll go through all of this here. It's going to be really, really meticulous, and I'm going to be able to share with you the slides after. So if you get confused or get lost, it's quite okay. It is a confusing rule. So at the formal review hearing, the Florida Department of Highway and Safety and Motor Vehicles hearing officer will determine by a preponderance of the evidence presented whether sufficient cause exists to sustain, amend, or invalidate the suspension of the driver's license pursuant to Florida Statute 322.2615. Really important, right? This hearing officer at the DMV is not a judge. It's not a magistrate. Sometimes it's a lawyer, but very rarely it's a lawyer. It's kind of just someone that at the DMV who's been promoted or has gained their position because they've done so well or whatever it may be. I don't know what excess training they've actually had on that. I don't know that. But really, they're going to be evaluating case law. I cite case law in my hearings. And it's really important that you understand and tell your client that the state percentage of winning these is very, very low. And what does it actually entail? Okay. What is that 10-day rule? First things first. Got some of the greatest dunkers here. We got Michael Jordan, we got Spud Webb, we got Dominique Wilkins, right? We're missing Vince Carter. Once you've been arrested for DUI, okay, you only have 10 days to challenge the administrative suspension of your driver's license. So you've been arrested. You come into my office. You've got a ticket. That ticket for DUI is going to function as your full-blown license. You're not in a hardship yet. For 10 days, it's like you got your license, but your ticket functions as your driver's license. Within that 10 days, you need to make a decision. Do I do a formal review with the DMV and challenge my arrest, meaning that I'm going to challenge the stop, I'm going to challenge the probable cause, I'm going to challenge the breath, I'm going to challenge the refusal, I'm going to challenge a bunch of facts about the arrest and say that the DMV doesn't have enough evidence to suspend my license. And if you win that hearing, the suspension's gone, totally gone. However, if you lose the hearing, there can be some adverse consequences. So here's the 10-day rule. There's a difference between whether you gave a breath or you refused a breath, okay? If you refused a breath, there's a 12-month suspension for your first offense. Okay? If you waive that formal review hearing, so you're faced with the option to waive, or you're faced with the option to actually do the hearing. If you waive it, you're eligible for a hardship right away. There's no hard suspension. A hard suspension is no driving whatsoever. There is no hardship. You got to Uber or Lyft wherever you're going. If you elect to do the hearing, okay, if you lose the formal review hearing, then your license is suspended for 90 days without an ability to get a hardship license until those 90 days pass. If you win, then there will be no suspension of your DL. So it's a risk reward. Here's second, right? If you blew a .08 or above, it's a 6-month suspension for your first offense. And if you waive the formal review, you're eligible for a hardship right away, same as the previous, right? Same as if you refused. However, if you elect to do the hearing and if you lose, it's the same as the other one, but it's a 30-day hard suspension. So what you're really going to understand here is what are the pros and cons if you typically lose this? Well, let me tell you guys, let's take a step back. Let's see the forest through the trees. At this formal review, you can subpoena and call the officers and witnesses to give testimony. Sometimes they do it telephonically, sometimes you go into the DMV office. And what you need to understand, all right, is that the officer, and I'll go to the next slide just so we have it, right? This is to keep in touch with me, go ahead and scan it. But what you need to understand is this super important. The DMV hearing is an opportunity to basically get a free deposition because you're going to be able to cross-examine that officer, you're going to be able to question that officer, and there's going to be a transcript made of it. Well, there'll be an audio collected. You can always request the audio and then hire a court reporting agency to transcribe that audio so you can have a transcript. It's going to be testimony taken under oath, so it's going to be able to be used in court. If you are in a jurisdiction that does not allow for depositions, okay, you can use this for your depo to make your case better, to have a transcript to impeach at a motion to suppress or at a trial. I highly advise to do the work and take the DMV hearing or do the DMV hearing if your client is properly advised of the negative consequences and he or she can survive with that hard license suspension. Because it's very rare that you win these hearings. Okay, you can appeal them. But what we want to do as well when we're talking about these DMV hearings is take a step back even further. At that initial consult, you're going to want to advise your client what he or she should do, but it's very subjective because you need to hear from them as to whether they can maintain their livelihood or get by with that hard suspension. But the clock is ticking, right? There's 10 days to make this decision. And so it's really important that it's covered during your initial consult strategy session or phone call with your client. And if the 10 days have passed, there's not really much you can do. You can try to reach out to the DMV. You can try to present a reason why maybe something wasn't done. But really, that 10 days is a really hard deadline to get through. So we don't want to pressure sale any client to sign up or need legal services ASAP. But this is actually something that's super important to them. Not just for the purposes of their license, but now as we see the forest through the trees, the case itself and the officers. I did have time available here for questions and answers. I don't see any questions at the moment. So I will provide some additional comments if I can go back. So one of the things I really want to talk about is when we're getting to know our clients, all right? If we're going to talk about that second DUI, it's something that we should really strongly talk about. What is the difference between a second DUI within 5 and a second DUI outside of 5 years? That 10 days, the second DUI outside of 5 years of a previous condition, there is no 10-day mandatory jail sentence, okay? So that's something you're really gonna wanna talk to your client about so they understand that if it's a second outside of the 5 years, you're not dealing with mandatory jail. Now, there are certain judges, and this is why you gotta know your judge, that will still give you some serious jail time if you were to lose or try to take a plea on the case. But that's something you need to discuss. Here's another thing. There's a video on our website. You can look it up on our YouTube website, and it talks about why a reckless driving or a careless driving is a win in a DUI. And what's important about a DUI, right? This is some just background information that you want to share with the client so they know how serious this is. So some people think, yeah, it's just a DUI. Guess what? If you don't beat a DUI and you have to take a plea, there's no withhold of adjudication. And if you guys aren't familiar with what a withhold is and you're watching this, it means that you have not been convicted or adjudicated. Adjudication, conviction, synonyms, same word. And if the judge or the state attorney withholds that, you've not been convicted. Guess what? If you have an eligible statute, you can seal that off of your record. However, if that conviction comes down and you resolve that DUI, the statute says it's a mandatory adjudication. So there is no such thing as that withhold of adjudication. So you're really going to want to emphasize to your client that, look, when we're talking reckless driving, it's a win, but I'm giving you options. Remember, we think back about when I said I want to give my client options at the strategy session. I want you to have the option to potentially beat the DUI and seal this off your record while maybe having to do some probation or some driver's license suspension down the road, or we can go to trial. If we're getting a reckless driving, it's likely because there's a good case, either a legal issue or factually at court, it's a good issue. But those are all things you're going to want to discuss, as well as you're going to discuss insurance, okay? If you get convicted of DUI, the FR44 insurance, is very pricey. It's super expensive. Now, you may have the SR22 with the reckless driving, and it may go up with the careless driving, the insurance, but it's nowhere near what that big FR44 insurance is with the DUI. Also, when you get into the reckless driving or careless driving conversation with the state attorney, you are able to then move around the parts. Things become negotiable. Those statutorily required conditions of a plea to DUI are no longer quote unquote required. We can move around with them. We can play, right? Things are opened up. And really what I want everyone to understand here is that when we set this up, when we set your case up, we're setting it up for litigation. We're setting it up to fight, okay? I have never, ever told the client that I'm not going to overturn every stone to beat their case. And hey, let's do 3 out of the 4 stones have been overturned. We don't need to look at that last one. I kind of know what's under there. No, let's do the work, guys, and let your clients know you're going to do the work for them. Because what's really important is that your strength at trial and your strength in a litigation phase, like at a motion, is going to determine your strength at the negotiating table. Okay, so you're going to build your case as strong as you can. If you make yourself out to be a run-of-the-mill regular lawyer who's just kind of going through the motions, the state attorney is just going to think that they have their case in the bag or not think anything special of it, and then you may have to fight the case at trial if your client wants to go to trial, and you're going to look back and go, wow, I really wish I did some of the work to make this better. But what's really important is if you set up that trajectory and you start talking to your state attorney and you say, hey, look, I've got mitigation, right? I've got a doctor's surgery report from his ACL. I've got a document that he came to this country at the age of 15 and English isn't his first language. We've had cases at our firm where clients have said, hey, I'm vertical. And what they meant to say is I have vertigo, but they were having a really hard time speaking it. And with the whole video, it wasn't just one word. The whole video was coming across in some Spanglish. And it really wasn't really translating well. And the officer just, I'm going to go ahead and make the arrest. It wasn't until we had to present evidence to the state attorney that our client's first language isn't English. In fact, she's still learning English and taking classes, et cetera, et cetera. Those are things you're going to want to show to the state attorney so it validates your defense. And if you file them as a defense exhibit, something of the nature, kind of gives the state attorney a little bit of pause, right? It kind of makes them think a little bit. Are we really going forward on this? How am I going to work on this? I'd rather work on the case where the lawyer doesn't really care about his case. That's probably an easier case for me to beat than the one where the lawyer's built it up and is ready to go. It has exhibits. And all of that starts from your initial client interview. And it's kind of crazy to think back on some of the cases we beat here that if we didn't take notes or didn't really give credence to our client's stories from the initial interview, we would never have beaten the case. For instance, we just recently won a motion to suppress where a client told us that he had a dash camera video, right? If you don't collect that dash camera video or don't ask the client if he has a dash camera video, he or she may not even think it's a big deal. We were able to review the video, present it to the state attorney. They still wouldn't break the case down, so we went to a motion, and we wanted a motion to suppress involving an improper start. But those are all things, right? Clients have cell phone videos of things that happen. We had a trial a few years back where a client gave us a video of him trying to record an interaction with the police, and they slapped it out of his hand. Now, if we hadn't discussed this with the client and see if we had a video, he or she may have been afraid to share it or just not know better that they should be talking to their lawyer about that. I know it sounds silly, guys, but a lot of people come into the office very nervous and they lose their common sense. So you want to make sure you steer that ship and give them some horse blinders and say, look, let's talk about some of the issues. Do you have any video? Do you have any audio? Do you have any text messages or GPS locations from that night? Those are all things that you really want to try to collect as you're going through your client interview. And so really that's what I have for you guys. I hope I didn't bore you too much. The client interview section is usually not the most exciting. My partners here at the firm are going to do a fantastic job with the rest of this. If you have any questions, I'm going to get it back to that QR code so you guys can take it. One final thing. My wife has never said this to me. If you're listening, honey, I love you. But when you have someone, right, and have you ever heard the saying, don't tell me you love me, show me you love me. If you're able to establish a timeline with your client from the initial interaction, if they are enrolled in DUI school right after they meet with you, they do the follow-up treatment, they start some community service hours, they maybe do an NAAA meeting, right? Even if they may think they don't need it, right? Those are all things that when you talk to the state attorney and you say, oh, my guy's a great guy, he's a hardworking engineer who's supporting his family, he's trying to start his business, this would crush his dreams or set him back tremendously. Please, can we get this into a reckless driving category? That's me telling the state attorney how great he is. Don't let me tell you. Let me show you. So if you build that timeline out of him or her taking those actions, right, really getting there, moving the ball on their own without the judge telling them, without the state attorney telling them, right? Let their client look like the movie star. You can be the director. That's something Adam says a lot, right? Let us be the director. You're the movie star. We'll help you and tell you where to go. We can't make you do things, but certainly if you set that up, if you set up a timeline on paper that I could show a state attorney, you've taken this seriously. You're not trying to pull a quick one here. We're taking this seriously. Other clients who don't do those things may not be looked at in a light most favorable by the state. So that's another thing that I wanted to touch base on here today is make sure that you know the client is going to be the movie star and you're going to be the director. Guys, thank you for your time. I appreciate it very much.